We'll now call the case 120744 in the matter of Thomas K. LeBoon. As I had indicated earlier, the Chief Justice and Justice Beyer are recused on this matter. We are pleased and honored to have sitting with us today Judge Dan Cahill from Kansas City and Judge Steve Montgomery from Paola, who have been willing to give up their time to come and sit with us today to hear this important matter. So, with that, counsel.
May it please the court, Stan Hazlitt appearing from the Disciplinary Administrator's Office. Justice Lukert, I would like to reserve 2 minutes.
2 minutes is reserved.
This is an original action in attorney discipline. The hearing actually took place on August 28th of 2018, at which the panel considered the respondent's conduct in 2 separate civil cases. It was one case was filed in Miami County in which the respondent represented the plaintiff, who accused or alleged that the state hospital and its staff allowed his client to be attacked by other patients. This was filed in Miami County. The hospital, the secretary of SRS, and the director of the hospital were named defendants in that case. In the second case, which was filed in Dickinson County, the respondent represented a roofing company to foreclose a mechanics lien, and also he sought damages for defamation and breach of contract. The panel hearing this case made findings that the respondent violated a number of rules of professional conduct in his representation in both cases: competence, diligence, conduct involving dishonesty, and conduct prejudicial to the administration of justice. Procedurally, the stipulation was entered into in this case, in which the respondent admitted to many of the facts and to rule violations. The respondent has filed with this court a statement pursuant to Supreme Court Rule 212C with the clerk, in which he informed the court that he does not take exceptions with the findings made by the panel, but he does wish to address the issue of the recommendation made by of discipline made by the panel, as well as mitigation. With respect to the recommended discipline, our office and the panel recommended indefinite suspension from the practice of law. The respondent recommended a suspension of that suspension, and the respondent be placed on supervised probation. The respondent's counsel, as I read the record, suggested a 3 or 4 year period of supervised probation. A plan for probation was presented by the respondent to the panel in a timely fashion 14 days before the hearing occurred, and the plan was in effect at the time of the hearing. The respondent has filed an affidavit with the clerk in which he represented that he is in compliance with the plan. Kind of want to address the misconduct that occurred in these 2 cases real briefly. Panel found that there was a violation of, and the respondent admitted that there was a violation of KRPC 1.1 competence for filing an untimely expert witness designation. It was not signed by the expert, as is required by the local rules in Miami County. Actually, there were 2 designations of expert witnesses that were filed by the respondent, neither one of which were signed by the designated expert as required by a local rule. The panel found that this was a violation of the rule on competence. They also found that the designations did not comply with what is required, which is that you have to cite what it is that you're relying upon in reaching your recommendation or your conclusion. There was a finding of a lack of diligence in both cases.
Can we back up on one of the experts? There was also an indication from one of those experts, I think it was Dr. Horton, who indicated that he never even agreed to be an expert. Is that right?
That's correct. There was...
and that was a misrepresentation about his status on the case. He never agreed, and he didn't think there was any fault by the defendants in the case. I think he expressed that opinion too. Is that right?
That is correct. The first expert designation was under the name of Dr. Horton, I'm not sure he was a doctor, but he may have been a psychiatric nurse, but at any rate, he did not agree that there was any culpability on the part of the hospital.
Right.
The respondent has taken the position and has explained that he took notes from a number of different experts that he talked to, and he just put Horton's name in there and it was the wrong name. What the court ultimately concluded, the district court and the Court of Appeals concluded was, you know, if you just would have followed the local rule and had the expert witness sign the affidavit that was required, it wouldn't have happened, because obviously Mr. Horton would not have signed something like that because he didn't agree with the plaintiff's theory of the case. A lack of diligence in both cases. In the Miami County case, the hospital case, this was crucial, because ultimately that case gets dismissed as a result of the respondent not acting diligently. In August of 2017, when Judge Arnold Berger reported this matter to our office, she stated in her complaint that the case was dismissed, quote, solely due to Mr. Boone's inaction and failure to meet deadlines or request extensions. Judge Harth, the district court judge, said, the plaintiff has, with very rare exception, failed to comply with deadlines set by the court or agreed to by the respondent. As I said, there was also a finding of lack of diligence in the roofing case filed in Dickinson County. In both cases, there was a finding of violation of KRPC 3.4, fairness to opposing counsel. This is because in both cases, the respondent failed to promptly reply or comply with discovery requests. In fact, in the roofing case, he was assessed sanctions, monetary sanctions, by Judge Platt, who heard that case. This is kind of back to what you were talking about, Justice Rosen. The panel found an 8.4C violation involving dishonest conduct. In the Miami County case litigation, the respondent designated a person named Don Horton as an expert witness. And I don't think anybody disagrees with this, Mr. Horton was mistakenly identified by the respondent as an expert, when in fact Mr. Horton had told the respondent that he did not believe that the plaintiff really had a case. And as I said earlier, this wouldn't have happened if the local rules would have been followed and the affidavit of Mr. Horton would have been signed by Mr. Horton, because he clearly wouldn't have signed the affidavit under these circumstances. The panel found that the respondent misled Judge Harth on a hearing on a motion to dismiss on November 7th of 2014, when he told the court he had designated a second expert witness because Mr. Morton was unavailable, rather than the truthful answer, which would have been that he had been mistakenly identified and did not have an expert opinion that supported the plaintiff. And finally, 8.4D, which is conduct prejudicial to the administration of justice. The panel found this because the respondent failed to prosecute the Miami County case, the hospital case, in a timely fashion, which caused significant delay and resulted in the dismissal of his client's case. And the court also found that, or the panel also found that this prejudiced not only his client, but the defendants in the case and the administration of justice. So the question becomes, what's the appropriate discipline in the case? As I said, the panel in our office recommended indefinite suspension. The respondent has requested probation. The panel found, and I agree, that probation is not the desired result in this case. First, there's a finding of dishonest conduct. This court has held that that sort of behavior cannot be effectively supervised. But secondly, pursuant to Supreme Court Rule 211G3, that rule requires that the placing of the respondent on probation be in the best interests of the legal profession in the state of Kansas. A little background here. The respondent was first placed on supervised probation by this court back in 2000, and that lasted until 2009. There was a request for an order. There was an order of show cause that was issued because right at the very beginning of that supervised probation, there were some additional cases involving rule violations. The court decided that the respondent had implemented some changes in his practice that would allow him to continue to practice. And later on, there was another disciplinary case in 2013, after which involving additional misconduct, after which the court said, well, we'll just extend your probation 5 years. So from 2000 to 2009, the respondent was effectively on supervised probation. Shortly after being released from probation by this court in November of 2009, the respondent filed the litigation in Miami County against the state hospital. By 2011, a motion was filed in that case by the defendants asking that the case be dismissed because the respondent had failed to prosecute the case. It was voluntarily dismissed and then later refiled by the respondent. In July of 2012, the respondent filed the case in Dickinson County. Throughout that decade, really, literally, the misconduct in those two cases continued. So from the year 2000 through up until just recently, the respondent engaged in misconduct. The panel found that the respondent's conduct harmed his clients, prejudiced the defendants in the cases, and the administration of justice. Given these facts, I would argue that it is not possible to conclude that allowing the respondent to continue to practice law is in the best interest of the profession or the state of Kansas. The panel pointed out that the conduct in these present cases mirrored the conduct that got him in trouble in the first place back in 2000 and through that decade. I don't know, the respondent in the previous cases and the respondent in this case has talked about the health of his parents, previously his mother and his father in this case, and I'm sympathetic to that. I mean, he was taking care of his parents, but those are the primary reasons given for the fact that he was not able to practice law effectively. And he just hasn't. I mean, we've seen that time and time again. I believe indefinite suspension is the appropriate discipline. What the panel found was a respondent's knowing violation of his duty to his clients, to the legal profession, and to the legal system, which caused injury to his clients, the profession, and the legal system. I'll be happy to answer any questions.
Any questions? Thank you, Mr. Haslam.
Thank you.
May it please the court, John Ambrosio on behalf of the respondent. There's no question, and I didn't take exceptions, the facts and the violations as described in the panel report are accurate, and we stipulated to all of those facts prior to the hearing. The whole matter before this court and to the panel was, what do we do with Caleb Boone? What should the punishment be? What should the sanction be? There's no doubt that the respondent has had a long and torturous history of disciplinary problems before this court. He's had panel reports before, and my colleague is right, that he was extended on probation for more than 8 years, close to 9 years. Did a pretty good job of managing himself, his life, and his practice during those times. These two cases, as described by the panel and my colleague and my client during his testimony, is more the same mistakes are made. And here's the problem. There are some amongst us who just can't run a law practice by himself or herself. They can't come back to the office and say, something is due January 4th. Please put that down on the calendar, put it down the electronic calendar, and bring it to my attention 2 weeks before. Witnesses and exhibit lists are due February 15th. Put that on the calendar, etc., etc., etc. Some people have a hard time with that. Some of us have been lucky and had the training that we don't have those problems. Mr. Boone has had problems with that before. Since we put the probation plan in effect this time with Mr. Dennis Davidson, where they meet once a week other than when they both had trials, where they talk about the next week's calendar, they talk about what is going on in Caleb's practice, we have not had any major problems like the ones described in this situation or in the probation that occurred a number of years ago when he was on probation for 9 years. When he is taken care of, when he has somebody who writes things down and makes him do what he's supposed to do, he doesn't have problems. I'll give you an example. He did an interview with a number of witnesses who were going to be expert witnesses. And I agree with Mr. Hazard, one of them was a nurse, he was not a doctor. And he wrote down those notes, and he misconstrued and then didn't follow the rule. Somebody who is monitoring his practice is going to say, look, Mr. Boone, there's a rule, and you've got to follow the rule. You've got to put everything in a report, and your expert is to sign off on that report and before you give it to opposing counsel and before you give it to the court. He would have known that. He wouldn't have made that mistake. He wouldn't have made a misstep in mixing up the two things. And on the issue of addressing the court, it wasn't a lie. It was a misstatement. He was nervous. He was negligent. He made a misstatement. This is a person who's very, very bright. I accused him at one time of being almost having Asperger's syndrome, but he doesn't have any mental illness, and he has not been in any way diagnosed with that syndrome. He's different, he's odd, he's different when he deals with people, and I think this irritated both Judge Platt in Abilene and maybe Judge Hart up in Miami County. I don't know. But he made enough mistakes where the court probably had a right to rip his throat out. And they were angry. The Court of Appeals talks about it. This is what goes on when we have people who don't follow the rules. Then the district court judges, the trial judges get frustrated. I think we have in place now a supervisor who's the next town over who can meet with him and is meeting with him on a weekly basis that will help him continue to be able to practice law. And that's all I have, but my client would like to address you, with your permission.
Mr. Boone?
You gonna go? You stand with the lectern, I'll...
Thank you. May it please the court. I sincerely apologize to all of you, and I sincerely apologize to my clients in these situations. And in my own thinking, it's just unfathomable to me that I would be in this position. But of course, that's my own comment about myself. And I recognize that I am responsible, and I'm the only one responsible for my actions. If my counsel will allow me, I would like to state concerning my statement about what Mr. Horton told me that he could not be available. When I called him on the telephone and checked with him, he told me that he would just not be available. That's what he said to me on the phone at the end of that process, when I realized that that designation had been made. And what I did in that instance was accept his statement that he was not available. At that point, I was still confused about who the expert was. And therefore, I immediately proceeded to get a substitute expert who was a PhD psychologist from Olathe. And the only thing that I can say about these situations is that I'm responsible for them. And I don't deny that. I have been on probation with Dennis Davidson. We have had a very good relationship. I have seen him regularly. I gave an affidavit concerning that. And he has made good suggestions to me about what to do, and I believe I've been able to follow his suggestions. My father passed away in August 25th of 2014. I practiced with him. I should say to this panel that during the time that he was in his later years, and this would be particularly about the last 5 or 6 years of his life, bless his heart, he was in very poor health. He did not realize that he was entirely, but as such, he was just simply not able to come to the office on a full day schedule. But he did every day, he came every day. But I was running the entire practice essentially by myself. I was also taking care of essentially all the expenses of the practice in those later years. We were not in a partnership, we were in an association with a suite of offices. He had his own cases, I had my own cases. I did consult with him on some of his cases. what I'd like to respectfully say is this. I do believe that as a lawyer, I have done in my practice what I would like to respectfully state are some very successful and outstanding things for my clients. And I want to, in that sense, stand up for myself because I think that I should at this time. Also, recognizing this, my responsibility and not ignoring it. I ask the court to allow me to continue to practice with probationary restrictions, with Dennis Davidson acting as my probation supervisor. His office is only 30 miles away, and he was a partner of Marvin Thompson, and I'm well acquainted with that practice. Dennis, I would not call Dennis a personal friend, but I've known him over the years. And of course, through this process, I've gotten to know him very well, and he me as a supervisor. I recognize that this court has a duty to administer the licenses of attorneys and to administer the entire provision and dispensation of justice in the civil and criminal realm of the state. I understand that, and I respect that. And I believe sincerely that I can continue to respect that, and that I certainly do and will, and that through probation, I would be able to successfully and continue to successfully represent my clients on an ongoing basis with the appropriate restrictions. I should say to this court also that during this time, I think it is important for the court to note that during the last, well, it would be about the last 7 years, from 2012 to now being 2019, I have been able to have many successful cases, and I've been able to recover money for my clients. And I also should say that I've been able to work on some very complicated cases with a great deal of success. I understand that that does not in any way change the facts of this case. However, it does, I respectfully submit, it's indicative of my character. And so I want to communicate that to the panel, to your justices, your honors. I believe that I need to correctly represent myself to this court, and so that the court will know that I've been able to be very successful on many cases and in my practice in the form of representing my clients. I have not become a wealthy person. I don't want to give that impression, but I believe that I've been able to faithfully represent them and to help them. And I have continued to do so throughout this time. And I want the court to be aware of that. Those facts, I think, need to be presented to you. Again, I understand that those facts do not erase the circumstances of this case, and nor do I intend to make the Supreme Court think that I think that those facts erase, those general circumstances erase the facts of this case. I'm not suggesting that. But I know now, and I've always known, that this court has been wonderfully magnanimous to me. And that is something that must be said. And that judges and other attorneys in this state, with whom I have wonderful relationships, over many years have been wonderfully magnanimous to me, and I do not ignore that. And I thank the Lord for that, because of the fact that I have been shown so much goodwill in my life, not just by my family, but from the lawyers and judges I have known. And I would like to state in its own way, I would consider that to be my extended family. And I suppose that was something that my father kind of instilled in me, because he was so close to so many other attorneys and judges throughout the state. I understand that I'm not my father, I'm me, and I must represent myself to this court, and I must rise and fall on my own merits. I recognize that. But I also need to make sure that the court understands all of these other circumstances, which I think are important. I think they're relevant. I don't believe that they dismiss the facts of the case. And so I thank Your Honor, for your attention to me today. Just one moment, please.
What is the nature of your practice? What kind of clients do you see? What
yes,
kind of cases are you taking?
I will tell you. My cases consist mostly of civil cases. Right now, I have 30 civil cases, and those are not all fully active. Several of them have been settled, and they're in the process of being concluded. There are, among those civil cases, 6 medical malpractice cases. I recently had mediations in several of those, and several of them have been settled. That includes one legal malpractice case, which was recently settled.
It's a general litigation practice.
I just wanted to get an idea of what.
I'm sorry, I didn't want to necessarily go into too much detail.
That's all. That's fine. Thanks.
All right. And I have 11 criminal cases, 5 social security cases.
Indicated that you had answered this question.
Sorry.
My understanding is that you filed no exceptions to the findings of the panel, which included a finding of 8.4C, dishonesty or misrepresentation. It sounds to me from your statements here today that you don't agree that you engaged in that conduct.
Your Honor, the panel found that there was no dishonesty because of what my counsel referred to as the mistake in making the notes about the expert witness in the Zoradol case. Now, I understand that. I did take a petition for review to this court and argue on appeal to the Court of Appeals in that case that I thought that Judge Harth had found that I was fraudulent in my designation of an expert, and that's in the record, and I want to state that. But that was actually found not to be the case by the Court of Appeals in that first appeal. But yes, Your Honor, what I want to say is that I need to explain the circumstances, and I don't want to erase anything, but I just want to explain them. I think the court needs to know them. When I was told that when I designated the expert witness originally in that case, I mixed up 2 persons entirely and just got everything backwards. Now, I believe that has been accepted as I've just stated, that part. Then, Your Honor, when I was informed by counsel for the defendant, for the hospital, for the Department of Aging, that he had interviewed Mr. Horton, then I contacted Mr. Horton and I asked him whether he would be available as an expert witness in my case. And he said no. Now, I did not know anything about the fact that Mr. Horton had expressed specifically the views that he had. I had interviewed him before, and he had told me those things, but by the time that I got to that point, I had mixed up the notes, and so that mix-up in those notes continued until that point. In my mind, I was still under that misconception. And so then when I spoke to Judge Harther about that, all I treated it was as that he was no longer available on the case, because he said to me on the phone, "Mr. Moon, I just can't be your expert in this case." I did not press him for any details when I talked to him on the phone about that. And that is a circumstance that I think I should tell this court about. Now, I do not in any way want to try to deny the facts of the case
I don't
here.
think you're answering the judge's question.
I'm sorry, Your Honor, am I not answering your?
Yes, so you took no exception to the finding of the panel that you engaged in conduct of dishonesty or misrepresentation. If that's not the factual situation you agreed to, is there something else that you believe you did that left you not challenging that finding?
Your Honor, all I can do is just tell you what those facts are. You're asking me the question about that. I spoke to him. He told me he was not available. I told the court that.
Thank you.
And does that answer your
Yeah.
question, Your Honor? That's, and I had said that before.
May he continue?
You may.
Your Honor.
Wind up, please.
Yes, Your Honor, of course. One thing that should be said to the court, I believe, is that there's been a long span of time involved, and I'm not going to ignore that, but it also must be known that during that long span of time, as I said, I believe I've been able to well represent and be successful in representation of many of my clients. And I thank the court for its attention, and I respectfully ask that the court please consider allowing me to remain on probation with the appropriate restrictions that the court would consider. Thank you. Thank you.
I would say just real briefly that this really is a protection of the public issue. The respondent really hasn't done very well on or off probation. I mean, that's just a fact. If you look at this record and you see the amount of work that have been required of the district court judges who hear these cases, opposing counsel who has to continually try to get the respondent to respond in a timely fashion, to file motions to compel, I mean, it's a tremendous burden on those folks, the judges, opposing counsel, not to mention the client who just lost her cause of action. I mean, there is actual harm in this case to all three of those entities.
Can you help clarify this question of 8.4 and dishonesty?
I guess I would say initially that there were no exceptions taken to the
Right.
findings made by the panel.
But do you think the panel finding is accurate?
I spent a good deal of time yesterday looking at that finding, and I certainly can understand how they came to the conclusion that because the statement was made, I think, on November 14th or November 7th of 2014. The first designation of an expert witness was filed by the respondent. That was Mr. Horton on October 6th of 2014. The second designation of an expert witness, another person, a man named Gentry, was made on November 7th of 2014. The day that they were hearing a motion to dismiss, which had been filed by the defendants in that case. It was at that time that the respondent said to the judge that, this witness is not available, as opposed to saying that, this witness doesn't really support my theory.
Well, if the witness told him he wasn't going to testify on behalf of the plaintiff, what's dishonest about?
Well,
I guess I'm kind of,
well,
I understand there were no exceptions taken,
Yeah.
but
there was nothing in the record about that.
do you agree with the characterization of the Court of Appeals opinion that it found no fraudulent or dishonest behavior?
I certainly believe, Your Honor, that as I think everybody else in this case believed, that the respondent did not intentionally put Mr. Horton's name in there as a designated expert witness.
Well, what should we do with that? I mean, we've got a finding of dishonest conduct that was not, no exceptions are taken. And as far as I can tell, everyone standing in front of us here today is saying this was an accident.
That was an accident. The statement to the court, though, the panel found was not an accident, was intentionally designed to mislead the court. Either because he wanted not for me to speculate as to what the motivation was. I would say, in conclusion, that in my mind, you can take out the dishonest conduct finding, that probation should not be granted in this case if that finding's not even in there, because of the compelling reason that this is clearly not in the best interest of the state of Kansas or the profession that the respondent be practicing law given its history. Totally taken out the finding to which you referred.
Anything further? Thank you, Mr. Hazlitt. The court will take this matter under advisement and is